Welcome to today's meeting of the Joint Committee on the National Security Strategy. This is the second evidence session of our inquiry into espionage cases and the Official Secrets Act following the collapse of the case involving the alleged spying activity for China. Our objective is to bring clarity to questions that have risen in recent weeks to ensure proper accountability and to review the adequacy of processes and decision making. It's unusual for us to examine the details of such a case, but it is warranted given the scale of public concern. We heard on Monday from the Director of Public Prosecutions and government officials, and today we are hearing from ministers. I'd like to remind witnesses of their obligations to Parliament and the expectation of providing as complete answers as possible, and pithy, I would add to that as well. Can I first ask our panel of witnesses to introduce themselves? From my left.
Richard Hermer, the Attorney General.
Darren Jones, Chief Secretary to the Prime Minister and Chancellor of the Duchy of Lancaster.
So perhaps I could start with you, Lord Hermer, and I appreciate you weren't the Attorney General at the time the charges were first pressed in April 2024. But how might things have been done differently, assuming you wanted to prosecute?
Thank you, Chair. I'm mindful you asked for pithy answers. Could I just give a little background to the framework? Because I think that will help contextualise the direct answer to a direct question. There are two frameworks to bear in mind. The first is the Code for Crown Prosecutors, and that is a code that governs all prosecutors when they are deciding whether or not to bring charges. And there are two material elements to the code. The first is a prosecutor has to consider an evidential test, whether the evidence that the police or others have provided them gives rise to a realistic prospect of securing a conviction, the evidential threshold. The second, once you've carried that out, is the public interest. Is the public interest met in bringing the prosecution forward? Those are decisions that, except where Parliament has said otherwise, are solely for independent prosecutors. Now, there are some instances, there are about 50 offences on the statute book, in which law officers, the Attorney General or the Solicitor General, have to consent to the prosecution. And that includes prosecutions under the Official Secrets Act of 1911. And when the law officer considers whether or not to grant consent to a prosecution, the prosecutors will already have looked at it and carried out their own assessment. But the law officer has to carry out their own independent assessment, again, asking whether the evidential test has been satisfied, and if so, whether the public interest merits prosecution. And in this case, under the previous government, a law officer considered the materials provided to him by the Crown Prosecution Service and reached the decision to consent to the prosecution going ahead. That is the end of a law officer's engagement in a prosecution. Quite rightly, under our constitutional framework, politicians do not, save where expressly mandated by Parliament, do not get involved in prosecution decisions. That's formalised in the framework agreement between the Attorney General's Office and the Crown Prosecution Service. The current version is one that was signed in 2020 by the then Attorney General, Suella Braverman. And that makes plain that the CPS is an independent prosecution service, and that there are very limited circumstances in which law officers will even be consulted or informed about prosecution decisions. And most relevant to this case are the circumstances in which an Attorney General or Solicitor General will be approached about a decision to drop a prosecution where that prosecution started with Attorney General consent. And the framework agreement makes a very clear distinction. Where a prosecution in those circumstances is to be dropped because it is no longer considered to be in the public interest to prosecute, so that second limb of the code, law officers must be consulted. However, Where a decision is taken on evidential grounds not to proceed with a prosecution, then the obligation is to inform, not consult, to inform law officers after the decision has been taken, and that's what occurred here. So, Chair, I hope that is kind of helpful in kind of setting out the framework, and it leads to my answer to your question, is that on the materials that I have seen, I don't think that the law officer who made the decision to consent at the time of this prosecution reached, in any sense, an erroneous decision.
I think many, certainly the public, struggle with this because a common sense application, and if it had gone to jury, the common sense application would have been, are they an active threat? And I think many of us would assume that they may have come to that conclusion. But I was looking at what Ken McCallum and Chris Wray were saying back in 2022, Director of FBI and, of course, our MI5, and saying the attacks on our economy, I mean, they're multiple. In terms of espionage, you look at the attacks on our institutions, of course, this is allegedly part of. You look at the attacks on our democracy and the hack into the Electoral Commission. This is systemic. So I think when you hear Ken McCallum describing the CCP as the most game-changing challenge we face from all nations, then you think, how on earth is it that we've got to this situation? So I guess my question is, the DNSA was describing China as presenting a range of threats, but the DPP was concerned about being able to present a case of an active threat. Why is there such a difference?
Can I answer that question in two parts? So the first part is, I mean, obviously the best evidence for you as to the CPS decision-making and the rationale for that decision-making is the evidence that you received from the director and from Mr. Little. Everything that I have seen shows me that this was a prosecution service working hard to try and secure a conviction. They had an array of evidence. They were disappointed that the prosecution couldn't proceed. It wasn't
were you
just
disappointed?
Yes, absolutely, of course. They were disappointed that the prosecution couldn't proceed. It wasn't just a decision of one individual. It was a team of experienced prosecutors. They were aided. You had evidence from Mr. Little. Mr. Little is the senior Treasury counsel. He's the most experienced KC we used in criminal cases, and I use him in our most important criminal cases.
But they say they struggled to get evidence.
Well, look,
there was no evidence forthcoming.
My first point on this, Chair, is, look, these are people who are working in good faith to try and get this case into court. The second is, standing back in this case, where's the problem? What is it? Because I think we should all be concerned to try and identify what lessons can be learned. Wherein lies the problem? I'm clear in my mind that certainly one very significant problem here was the Act. And the Act wasn't fit for purpose, it was out of date. So the Act under which this prosecution proceeded was the 1911 Official Secrets Act. That was an Act that was introduced in July into the House on July 1911, and it received royal assent a few weeks later in August. And during its passage, there was lots of concern raised that it was not properly scrutinised. In 2017, the Law Commission flagged that the term enemy was deeply problematic and it would give rise to difficulties in future prosecutions. And I think what has played out during this prosecution exemplifies and highlights the difficulties with that term. That is why Parliament was right to pass the National Security Act of 2023 that takes away the problems that were faced by the CPS in this case. You no longer have to prove evidence, you merely have to prove that information was being passed to a foreign power. Speaking frankly, I don't understand why it took Parliament so long to pass that. Had that Act been in force at the relevant time to this case, between 21 and 23, I have no doubt that the prosecution would have proceeded to trial.
Lord Sedwell.
Thank you, Chair. Thank you, Attorney, for being with us today. I'm very conscious of the law officer conventions and so on, so I recognise you'll have to be careful in some of your answers. I really just want to get to the simple point of law on which this case failed. We heard a lot of evidence from Mr. Collins about the nature of the threat, the series of threats China places. We heard from the DPP about the tests they set, and colleagues will dig into those in more detail. But at the heart of this is a very simple question, which is the government believed, on the legal advice that they had, that the witness statements Mr. Collins had provided passed the appeal court threshold, and the CPS concluded that they didn't. Who was correct?
Could I, again, and we'll answer that question directly, but just take a step back, because I think it is important to remind ourselves that the test that needs to be met under the 1911 Act is enemy. So the jury need to be convinced on the criminal standard, beyond reasonable doubt, in this case, that China was an enemy. Now, the Court of Appeal, in the Rousseff case that I know you were discussing on Monday, in the Rousseff case said that you can satisfy that test as a matter of principle if you can show that a country is a threat to national security, but, and this is quite an important but, it's a matter of fact and degree. And they say that because it doesn't mean that you can ignore the test of enemy. A jury still needs to be satisfied that as a matter of fact and degree, the threat was such that China was an enemy. And the difficulty in this case was, and would remain if we were still governed by this statute, that it wasn't simply a case that the government was neutral on the question as to whether or not the threats meant that China amounted to an enemy. The government's position was that it was not. And so I anticipate that if this case had proceeded to trial in the hands of a skillful defence advocate, Mr. Collins would have been asked, let's say it would be Dame Emily back in the day in court. Dame Emily would start her cross-examination by going, the test here, isn't it, Mr. Collins, is you've got to be satisfied that China was an enemy, to which he's going to, of course, say yes. And shall we look at what the Foreign Secretary at the time said in his Mansion House speech, where he sets out the government's position, and he says, you can't call China a threat. Then shall we look at what, and I'm not making a political point here, these are the statements at the relevant time, what Ms. Badenoch said when Secretary of State, that she wouldn't call China a foe. Now, that's the kind of where you're going to start off, I anticipate, with a cross-examination. And of course, Mr. Collins is going to have to accept that. And when it would be put to him, you're not saying China is an enemy, he is obviously going to have to answer in accordance with the government's position. He'll have to answer no. That's the problem with a statute that was designed for the world in 1911, but wholly unfit for the world and the threats that this country faces in this century. And that is why Parliament was right, but I'm afraid late, in passing the 2023 Act. So those are the type of problems that I anticipate would have given rise to the prosecution. The problems that the prosecution would have faced in this case. But as to the actual thinking and the rationale, then obviously you've got the DPP and you've had his evidence on that. But that's my take about what the real difficulties are here.
So I understand that. I do understand that, Attorney, and I'm sure the government lawyers understood all of that as well. And indeed, it should have been apparent to everyone from the start that this definition of enemy, as you set out very cogently, is a real challenge. By the way, I suppose I should declare an interest, as I was the National Security Advisor who began the process of crafting the legislation that became the 2023 Act. And the reason Parliament was late on it was we could never get parliamentary time beforehand. And so I'm pleased you think the 23 Act passes that test. But my question again is just a really simple one. We heard from Mr. Collins, we heard both in written and in oral evidence, that the government, the Cabinet Office, were surprised that the DPP, the CPS, decided to drop the case because they concluded, for the reasons you just set out, that the threshold set by the Court of Appeal had not been met. Notwithstanding the language around national security threat and so on, which I'm sure colleagues will want to come to with you in a moment and just interrogate that in more detail. But the government clearly believed, on the legal advice they had, that the threshold was met, and the CPS concluded that not only was it not met, but it was that the case fell so far short of it that they couldn't even put it to a judge, let alone a jury, and therefore had to drop the prosecution. Those two cannot both be correct. Those two interpretations of the law cannot both be correct. And so I'm asking you, as attorney, as the senior law officer, as a matter of law, I'm sure you understand, you've set out why you understand why they got to those conclusions. But as a matter of law, one of those two interpretations is correct, which, as the senior law officer, is correct.
I don't think from the kind of, if we're talking about the government's position, I don't think that's a legal position that the government are advancing. What Mr. Collins is being asked to do is to give evidence, not provide a legal analysis. He's giving witness statements at the request of counter-terrorism police, and he's giving the answers as best he can within the kind of four squares of what the government policy was at the time. So it's not as if you have on one side a government legal analysis. You've got the evidence from Mr. Collins, and you've had his evidence as to how he thought that was sufficient. He was answering everything, all the questions he was asked to answer as best that he could. So but that's not a legal analysis. It's not a conflict between two legal analyses. You've then got, on the other hand, the CPS, who do consider at the outset of the case that there is sufficient evidence. There is then, as they approach the trial, not least through their own experience of having to fight another very rare case under the Official Secrets Act in RUSAF, which is the same prosecution team, as they're approaching this trial, as you would expect, sort of looking again at the evidence, testing it, assessing how it's going to play out in court, they reach a conclusion, for the reasons the director has given you, that the evidential test is no longer met, and therefore they are bound to offer no evidence. So I'm not sure Lord said, well, I accept the premise that what we've got here are two conflicting views of the law. That's not how I see the government's position. What I can say, both from the perspective as Attorney General and somebody who also sits on the National Security Council, is that you've obviously kind of got this kind of tension between, on the one hand, the National Security Secretariat's evidence as to what occurred. You've then got a bit of tension with the CPS's. What I see are, on both sides, really quite extraordinary public servants doing their absolute best. You've got Matt Collins, who I know very well, who is a superb public servant. You've got the CPS staffed with dedicated people. They're all trying to do their best, but they're coming from different angles. And it is not unusual in a prosecution per se to have everybody trying to do their absolute best, but nevertheless, you can't get a prosecution over the line. Okay.
Just one sort of further point from me. I think we will want to explore all of that, because we explored in some detail, Dame Emily did this the other day, whether actually the raft of evidence Mr. Collins produced on the range of threats that China poses, espionage, cyber, democratic, economic, security, etc., did actually cross that threshold, that appeal court threshold. And clearly the government believed that it did, because they were surprised
we lost Lord Sebel.
When the prosecution was dropped. But I take your point that in the end this is fundamentally, yeah.
We lost you momentarily. Hello? But I think
sorry.
I think the point was, I think it was understood. Yes. Yeah.
So just one sort of final point, but I think others will want to explore this in more detail, Attorney, is would it have been appropriate for your advice to have been sought as the senior law officer, superintending the CPS, as a member of the government, member of the National Security Council, on that question, and whether there was some other mechanism by which government might have provided additional evidence to satisfy the threshold that the appeal court had set?
I don't think there's a role for an Attorney General when it comes to the evidential threshold on the prosecution, because I think that creates a real danger of interference in operational decisions. So I don't think a request for me to kind of lean into the case, either on the kind of the CPS side or on kind of the government side, would have been appropriate here.
Okay, if we have more time, I'd like to explore some of that in more detail, but others will want to come in, Attorney. Thanks very much.
Thanks, Lord Savile. Lord Robertson. Sorry, not... Yes, Lord Robertson, and then...
my hand up.
Sorry, Lord Hutton. I think you did want to come in, but yeah.
Are we on the same question? Yeah. Just one question for you, Lord Hermer, which I'm struggling really to understand. Matthew Collins made it clear to us in his evidence that in his first witness statement, he would not describe China as an enemy. But you were very confident in saying at that point that the law officers concluded that there was sufficient evidence to bring a prosecution under the Official Secrets Act. That can't be right. If he's not going to say they're an enemy, why at that point did you think there was enough evidence to prosecute?
Yes, because at that stage, when the law officers were asked to consent, they were provided with the witness statements of Mr. Collins. I don't think at that stage there was anything to indicate that he would not say they were not an enemy.
Well, he was very clear. He was not going to say that China was an enemy. It's very clear in his statement to us.
Yes. Well, to be fair, Lord Hutton, I don't think he is clear in his statement that he would not say that they are an enemy. He sets out in those statements the range of threats that they pose, and I think on that basis, the law officer's decision to consent was not an unreasonable one.
Well, I think we need to check again on
yes,
that.
Of course.
It's very clear to us.
He's certainly clear in your...
He made clear he was not going to call them an enemy.
He was very clear about that in his evidence to you. In terms of the evidence that was available to the law officers at the time, that's going to consist in his witness statement. Of his witness statement, I'm so sorry.
But it was also clear from what we heard that Matthew Collins, who no one on this committee is impugning at all, he's an outstanding public servant, he was clearly being advised by departmental lawyers that what he was saying was enough to get over the evidential threshold. But then that turned out to be not the case.
I'm afraid I don't know the advice that departmental lawyers would have given to Mr. Collins. But again, although, of course, Mr. Collins was kind of in a slightly unusual position for a witness in a criminal trial, he's effectively giving corporate evidence. He's not doing so for the purposes of expressly seeking to meet a legal requirement. He's giving the evidence upon which a jury could then consider to see whether the legal requirements are met.
But that wouldn't really explain why he was surprised when the case collapsed, would it?
No, he's given you your evidence on that, and I don't seek to second guess or question that for a moment.
Mike Martin.
Thank you, Chair. Attorney General, I'm struck listening to your evidence and the evidence that we heard on Monday that we have a bit of an apples and oranges situation in that the Crown Prosecution Service quite rightly requires statements of fact in order to meet its evidential threshold. And the Deputy National Security Advisor, as a civil servant, quite clearly can only give evidence within the bounds of government policy. And he was clear to us that he was clear right at the beginning of the process when he was asked to give evidence that he could only give evidence within the bounds of government policy. So in August 2023, when he was approached by the counter-terrorism police and asked to be a witness, he said at that time, I can only give evidence within government policy. Do you think that actually there is a case to be answered that the DNSA, as a civil servant, was actually the wrong witness to speak to the fact of the matter that China is an active national security threat or otherwise? For example, could the counter-terrorism police or the CPS, and I'm interested to hear whether you think it's one or the other that's responsible for this, could we have called retired Director Generals of MI5 or the Director of Chatham House, a range of witnesses that could speak factually to the fact that China is an active national security threat? And was indeed the problem here that either the CTP, the Counter-Terrorism Police, or the CPS, in fact, maybe selected the wrong witness at the start of this process? Thank you.
Look, the short answer is I don't think there was anything inappropriate in asking the Deputy National Security Advisor to give evidence as to the nature of the threat posed by China between 2021 and 2023. And, you know, I, like all of us, am grateful that effectively he was prepared to stand up, expose himself to cross-examine at the prospect of cross-examination in court. He's a perfectly appropriate witness to get evidence from.
Sarah Champion.
Thank you, Chair. Attorney General, I'm struggling with two things.
Yeah.
One is why it was so late in the day that CPS decided that the evidence that Mr. Collins is going to give wouldn't be appropriate for the case. And the other thing is, why was it only one thing that these people could be charged on? Because my experience is child protection, and the police and CPS work hand in hand and tend to have a range of things they can charge with as the evidence starts unfolding. So was there nothing else that these two could have been charged on?
Well, again, I think these are probably questions that you're going to get much more direct evidence from the CPS, who made the decisions. It's their thought process, not mine. I mean, I can just kind of comment as a matter of generality,
Well,
which
your
is
past experience.
there's nothing unusual per se in, as you come up to a trial, in kind of carefully checking again your evidence, making sure that you've got everything in place that you want to have in place. I mean, that's my own experience of kind of 30 years at the bar, but I'm answering as a matter of generality, I want to say. I mean, the evidence as to the thought process is the evidence of the CPS, not of me. And again, I can't answer for the CPS as to their kind of thinking as to which charge to prefer and which not to. But again, as a matter of generality in my experience, although, I mean, I practiced in crime at the beginning of my career, but not throughout my career. But generally, you try and go with the most significant and the most serious. But not always. But again, I'm afraid those are really kind of questions that the director and Mr. Little are going to be best able to address.
But is it unusual to not have a backup?
It really depends upon the nature of the impugned conduct. There'll be some type of conduct that's covered by a whole host of crimes, and there you may want to think about it. There may be others in which, you know, the conduct is fairly unusual, and in which there's only kind of one crime or a small number of crimes. So it's really dependent upon the nature of the allegations.
Thank you.
Andy Slaughter.
Thank you, Chair. We seem to be establishing, particularly the evidence that we heard from the DNSA the other day, and also from the DPP, that there was a disagreement. There was a difference of opinion here. What I'm not entirely clear is whether that's a fundamental difference between what was in the witness statement and what was sufficient for the DPP, or whether it was almost there but didn't quite get where they wanted to go. But what does also appear to be the case is there's an absolute breakdown in communications here, a misunderstanding, so that several attempts are made by the government to provide evidence, and they are then not considered sufficient, and more evidence provided. But at no stage is it clear what should be happening here. And that seems a pretty fundamental, almost farcical breakdown of the way the system ought to work. So, I mean, are you happy that the system worked as it should? This might be a question for both witnesses. Or do you think that this is something which is, to say the least, does not show as working, it's not their finest hour, either part of the equation?
Look, I would just caution about rushing to categorise this process in those sorts of terms. I mean, what I haven't had the advantage of is to look through the voluminous case papers on this. There'll be an array of evidence. I haven't reviewed every page of it. I haven't reviewed every contact between counter-terrorism police and the CPS, every contact between the Counter-Terrorism Police and the Cabinet Office. And so it is easy, particularly when we are all so disappointed about the outcome of this case, it is a little easy to kind of jump to conclusions that may prove to be unfair. What is the case here is that you have got communications between CTP, Counter-Terrorism Police, CPS, Cabinet Office, NSS. Those are conversations that are going on. What you have is Matt Collins giving the evidence as absolutely as strongly as he feels rightly able to do so. You've also got the CPS who are taking advice at the highest levels as to what they feel they need in a courtroom to get this prosecution home. And there is a mismatch. Now, I don't think that mismatch need be categorised as a mistake or farcical. You're absolutely right to be looking at it. But I wouldn't rush to say that. These are all people working incredibly hard to try and get this prosecution over the line.
That does sound like you're saying that things worked as they should have worked in this case.
No, that's not me saying that. That's me saying we need to look at it really carefully to see if there are lessons that could be learned. That's why I welcome this committee investigation. What I am saying is I think it is unwise to rush and say this is farcical or it's a catastrophic failure. What I can see at the moment are people on both sides doing their best within their lanes. You've got the you've got the DNSA providing the evidence he feels rightly he is able to give. You've got the Crown Prosecution Service rightly working within their code for Crown prosecutors. And sometimes there are going to be tensions and conflicts between that.
Can I ask the Chancellor, is that your view also?
It's for the Attorney General as the Superintendent of the CPS to give his view. I have nothing further to add.
Nothing in relation to the way that the NSA prepared or created evidence at this stage?
No, I think the Attorney General's answered that question.
Dame Emily Thornbury.
We've heard evidence that the witness made a statement, his first statement, and then he says it in his letter, the joint letter that he gave from the Cabinet Office. So this is to the chair, and it's from the National Security Advisor and the Deputy Security Advisor, and he says it at point 3 on page 4. Where he says the drafting process took place between August and December 2023. It's an answer to question 7. You got it?
Yes.
Right. And then paragraph 4, he says drafts of this statement, this is near the bottom, of the statement provided to the DNSA included the term enemy, but he removed this term from the final draft as it did not reflect government policy. So this is before charge, right? So we've had between August and December 23, we've had a statement being made before anyone's charged with anything, and he's taken out the word enemy. Now you've put great faith in enemy is what this is all about, and so you've got your witness taking out the word enemy. Surely to any prosecutor, if they were thinking the way that you were thinking, they would think, well, that's a bit of a red flag, really, at that stage. And indeed, when giving it to the Solicitor General, who was the one who made the decision, presumably that was pointed out to him and said, got this statement, bit of a problem, the witness has taken out the word enemy and it appears in the legislation.
Yes. As I understand it, and I haven't reviewed the full papers that were before the then Solicitor General, what they were provided with was the signed statement of Mr. Collins. I return to the fact that I think when we look back at this episode, what we are going to see by way of a real mismatch is the statutory definition of enemy as opposed to the actual government's position between 2021 and 2023 that it wasn't an enemy. There is. I'd say sorry. The statutory. I'm so sorry. The statutory test of enemy in the Official Secrets Act.
Tell me what that is then.
So, to get the prosecution home, you need to prove that China was an enemy at the relevant time that the information was provided.
Yeah.
So that's the statutory test.
Oh, I see. All right.
Which
No,
you
no,
have
no.
to,
Yeah,
which
yeah.
you have to satisfy, obviously, on the criminal standard.
Yeah. And then you see, we also heard from Tom Little, the senior lawyer, and he at page 3 of the transcript. This is an answer to question 1. So it's top paragraph. Okay. He says, I also want to make it clear that I was not concerned if the witness did not use the word enemy. That would be a matter for the jury. But I needed to have evidence to support the submission to the jury, and the witness was clear to me, etc., etc. So he's saying he doesn't mind about the word enemy not being in the witness statements. So we've got I think we've kind of, on the face of it, we've got a bit of a difference here. So what they were relying on, and we can go through the various statements, but essentially the statements were, highlights are things like the Chinese intelligence service, this is in statement 1, are highly capable and conduct large-scale espionage operations against the UK and other international partners to advance China's state interests and harm the interests and security of the UK. We've got in statement 2, China also presents the biggest state-based threat to the UK economy. We've got in statement 3 that China's espionage operations threaten the UK's economic prosperity and resilience and the integrity of our democratic institutions. So we've got witness taking out the word enemy. We've got the senior counsel saying, I don't mind about enemy, what I care about is the evidence. And then we've got this case called Rousseff coming along, which people seem to be trying to persuade us absolutely threw the table over and changed everything, because suddenly we've got this case and we have to look at it all differently now. The trouble is with Rousseff is that it makes it clear that although they do talk about a current threat to national security, they don't say that is the new definition of enemy. They say this is an example. It includes a threat, right? So then we boil down to this. I'm sorry this is a long question, but I'm just trying to take you through what we've been kind of trying to wrestle with. And then we end up with the DPP saying that he had to drop the case because the witness was not prepared to say that China was a current active threat. Right? But when I asked him a question, he said that China was a range of current active threats. And if that is the reason that this case fell, no wonder we need juries, because juries have a bit of common sense where all these lawyers don't. Don't you agree?
The problem with which is a binary question at the end to a very long question, is I wouldn't be sure what I'm agreeing to and not agreeing to. So let me look. To my mind, the problem here is that for 110 years, we've had a statute that creates an unrealistic test for prosecuting those who engage in espionage against contrary to the national security interests of this country. And what this whole discussion demonstrates is that it simply was not fit for purpose. And that had we had the 23 Act in place by 2021, this prosecution would be starting in a few days' time. I've absolutely no doubt about it. But, you've got, on the one hand, we're faced with this kind of...
But wouldn't it need to be on the enhanced tier of FIRS before you...
I'm so sorry?
But China would need to be on the enhanced tier of FIRS, wouldn't it?
No, I don't think there would be a difficulty in this case in prosecuting, because I think what you're to show on this evidence is you could get in under the foreign powers provision. So this kind of demonstrates this whole debate that you can have people. I mean, the prosecution team here was a absolutely first-rate team. You've got the kind of most senior prosecutors at the CPS, including those in counter-terrorism. You've got the DPP. You've got First Treasury Counsel. They're taking great care about it. Mr. Little explained that he took the unusual steps of going to speak to a witness ahead of trial to try and just for himself make an assessment of where it goes. You've got various legal commentators talking about what Rousseff means and what Rousseff doesn't mean. To my mind, stepping back, it shows 1911 was fundamentally unfit for purpose. The new Act should have been brought in on the statute, but far sooner than it was.
Ed Morelli.
Thank you, Chair. To that point then, Lord Hermer, if it is, if a 110-year-old piece of legislation is not fit to prosecute people in 2023, you beg the question, why did the CPS decide that that was the correct law to apply in this case? And I think it goes back to linking up Sarah Champion and Mike Martin's questions, where the CPS seems to have gone down a route with a single piece, a single law under which to prosecute, while also relying on a single witness. And does it not objectively from the outside look like you are creating a single point of failure?
Well, there is nothing unusual in the criminal justice context in having to rely on key witnesses. And the success or failure of a prosecution depending on individual witnesses, that is obviously not unique in our adversarial criminal justice process. And again, to go back to Mr. Slaughter's question, I am loath at this juncture, not having lived and breathed the case, not having seen every relevant scrap of documentation, to effectively second guess. What I can say is from everything that I've seen that this was a team who were trying their best to get this prosecution up in light of what we will all agree were immensely troubling and serious allegations.
No one doubts the best efforts of those public servants involved. I guess the point of having an inquiry is to find out what lessons should have been learned and what recommendations should be made differently. So we can definitely put on the record that we all agree hard-working people doing the best that they possibly can. I guess what I'm trying to establish is, given your experience and looking back at this case, one in which right now we should be looking at the prosecution going ahead, as you said, of 2 Chinese spies, where did things go wrong? And if objectively you're looking back and going, at some point during this process, it was decided to go down a route in which we only had a single law under which we were going to prosecute, relying entirely on a single witness in order to bring around that prosecution. Were you not, if not setting yourself up for failure, then certainly creating circumstances in which failure becomes probable with only one thing going wrong?
Look, I really don't want to second guess what was the anxious consideration given by the Crown Prosecution Service to this case. But I do keep coming back to, if one wants to look at the kind of obvious fault line in this case, it's not, to my mind, necessarily in prosecution decision-making, it's in the Act that set a test that might have been fit, probably wasn't that fit in 1911, and certainly wasn't a fit in 2021 for prosecuting those alleged to be acting against the interests of this country.
Lord Boating.
You were informed that the case was to be dropped for evidential reasons. When you were so informed, you told us you were disappointed. Were you surprised?
Yes, I mean, I should say that I obviously knew the case was proceeding. I knew it was coming up in the autumn. So I think I was both surprised and disappointed, yes.
And you asked, presumably, why?
Yes.
You were told. Did it then occur to you that it would have been possible to have made additions to the indictment, to have added attempt or conspiracy? Did you suggest that to those who advised you that they were about to drop the prosecution?
No, and let me explain why. So I'm informed after the decision has been made by the director in accordance with the framework agreement. As you can imagine, I want to understand the rationale for that. That doesn't allow me to say, right, I want to see all the case papers, I want to call in the witnesses, I want to test it for myself, because that would be interfering with the prosecution decision. And it would be seeking to interfere in the prosecution. And I believe that would be contrary not only to the framework, but actually basic constitutional principle. So I was provided with a rationale that I obviously tested through questions as to the CPS decision making from their perspective. Obviously, if I thought at that stage that it was just a completely irrational decision that wasn't, for example, based on evidence, or had only been a decision made by one person of a junior rank, I would have asked even more questions than I asked. But I was satisfied that care and attention had gone into the decision. I was reassured by the fact that it wasn't just the decision of the CPS, but they'd had the most experienced external counsel consider it. And so it was obviously an information-only meeting in accordance with the framework. And so I didn't think it appropriate for me to roll up my sleeves and tuck into the prosecution case.
No, indeed. I don't think anyone would ask you to roll up your sleeves, but your lawyers around the table. We've all been lawyers around the table. And you're all very experienced. Everyone wants to do their best. Wouldn't it have been natural to say, well, what about conspiracy? What about attempt? I mean, you and I have been in many cases, have we not, when we've arrived at court and found that the indictment is an application to add to the indictment. It's not unusual. It isn't unusual for lawyers sitting around a table to ask themselves questions about that. Did it not occur to you to ask that question?
There's a very careful constitutional line. I mean, I'm not just there as a lawyer.
The constitutional line, but
no, of course.
Was there any discussion at all that you're aware of
without going into
charges?
I'm so sorry, I didn't mean to talk across you. Look, without going into the kind of the details of that discussion, I was satisfied that proper consideration had been given by the CPS to the evidence and to the charges that could be brought. I think you've also heard yesterday, I beg your pardon, on Monday from Mr. Little as to consideration of other charges that could be brought and his evidence on that. And that's obviously the first-hand evidence of most relevance to this committee.
You have told us you were disappointed and surprised. If you were disappointed and surprised, then imagine the scale of disappointment and surprise on the part of the general public.
Yes.
You were aware when you were informed of this decision that it would cause the general public really actually to question the whole system of investigating and prosecuting espionage cases of this sort. Did you express to anybody concern about the impact on public confidence in the whole system of justice in relation to espionage and in the security of this country? Did you express that concern to those who are bringing you this information?
My role at that meeting would not be to use public interest grounds to try and persuade the Director of Public Prosecutions.
There's no question, Attorney.
No.
Don't get me wrong, no one's saying for one moment that you were in the business of persuading anyone of anything. But did it not occur to you, and did you not express concern that this decision would impact on public confidence in the whole system of justice in relation to espionage cases?
I have no doubt that when I'm in a meeting in which I'm being informed of that decision, that anybody could have left that meeting with a sense that I was anything other than disappointed at the decision that was being reached. I am extremely concerned about the impact that this case has on public faith in our national security structures and in our criminal justice system, insofar as it intersects with that. And that's why I welcome the work of this committee. That's why I welcome parliamentary scrutiny. It's also, if I may say, why I have deprecate some of the baseless accusations that were levelled against the Prime Minister and against our National Security Advisor, Mr. Powell, when this information, but the decision of the prosecution was announced, that seek to suggest that politicians had somehow improperly interfered in this case to stop a prosecution. Effectively, allegations that they were perverting the course of justice against the national security interests of this country. Now, those were disgraceful allegations to make without evidence. They were baseless, as the evidence of the DPP and the Cabinet Secretary have made plain. That I was very concerned about, and that's again why I welcome this process, because it allows us to shine a light to see that we might not be happy with the decision, we might be disappointed with the decision that's reached at the end of the day, but these are decisions that are made through independent parts of our state, independent of politicians, and that is for the benefit of us all.
And you felt at the time there was nothing you could do about it?
Yes.
Thank you.
You'll understand how the public see this. They see spies being let off scot-free and no one protecting the state. Now, we've heard evidence that we have the people who made the decisions were, I think you said, first-class people, good people, working hard. But there's no accountability. No accountability in this system for the failure to prosecute spies that are damaging the UK. Now, we heard already that there were alternative ways that prosecutions could have taken place, but they were missed at some time. And I think what the public would want is some indication that there's some accountability in the system and someone will accept responsibility for it. Now, going back to the issue about the enemy issue, now, the previous government and this government have all trying to get trade ties with China and improve relationships. They're never going to call someone an enemy who they're trying to negotiate trade deals with. And I think that at the bottom line is that should have been understood at the heart of government, that was a test that was never going to be followed. So my question to you is, why is there no accountability in the system?
All of this would have been avoided if Parliament had heeded the call of the Law Commission to amend the law earlier than it did. The Law Commission raises precisely the point that you raise. It's very difficult for governments to call people enemies in the world in which we live, for all sorts of reasons raised by the Law Commission. That was a consultation that was published in 2017. They produced a full report in 2020, but you didn't need to wait for the full report to see the problem that they'd identified. And I think it is a matter of regret that Parliament missed an opportunity to get that on the statute books earlier than they did, because I think it would have avoided the very problems the Law Commission flagged up so many years ago. In terms of other charges that might be available, again, I think Mr. Little explained that they did give consideration to other charges, and I hope I get his evidence accurately when I say that his view was that they would all have required addressing the enemy test, whether you did it through the route of an attempt or you did it through a route of conspiracy. I understand that was his evidence. I can see some shaking of head, so if I've got that wrong, I've got that wrong. But his evidence was, I think, that consideration was given to other charges.
Can I just make that clear? That the committee's heard evidence that was not the case, that there could have been a case mounted and there was credible evidence which would have convinced a jury. Now, I think that we accept that the government of the day should have acted in a swifter way and should have seen that was a problem and taken the appropriate action. But the people who you're talking about as first class actually should have known that the reality was there anyway, and they should have took the appropriate action to take a case in a different way.
I think, out of fairness to those witnesses, those are points that the committee may want to make either in writing or a further session to the people who were the decision makers, who were the relevant decision makers. But I did understand that Mr. Little gave evidence to you on Monday that consideration was given to other charges.
There's a certain amount of confusion about this, I think we can agree. I'm reading the Integrated Review Refresh published in March 2023, which was whilst these two were operating, I believe. And it says, I quote directly, we have created and used new powers under the National Security Investment Act, which I believe to be the case. It then says, the DG of MI5 said, China was engaged in both espionage and interference in the UK. That was in 22. And then finally, it says, wherever the CCP's actions and stated intent threaten the UK's interests, we will take swift and robust action to protect them. But these two rather hopeless attempts at spying said they were taking money and they talked about spying. So it seems to me they were talking about spying, but what happened to swift and robust action to protect our country?
Well, the problem was that we were hamstrung by a 1911 Act that required...
When was the new Act implemented?
2023. So after the period. You couldn't charge under the new Act. You could only charge under the 1911 Act here. And the relevant period for determining whether or not China is an enemy is the period in which the offences were alleged to have been committed, which is 21 to 23. So the difficulty you get, of course, as Mr. Collins' statements make plain, you can absolutely build a case on a threat to national security. That's what his statements plainly say. But you still face the test of enemy. And of course, there's going to be, as you've alluded to, lots of evidence that you can put in the threat to national security amounting to enemy pile. But then you've also got the point in which the witness is quite rightly going to say, no, not an enemy. And indeed, the defence can rely on a host of statements from the government at the time saying not an enemy.
Well, you know much more about this than I. Wasn't there a case in 1913
yes.
under the Official Secrets Act?
Yes.
Where somebody, and we were not at war with Germany, so we didn't call them an enemy, but where somebody was prosecuted under the Official Secrets Act for exactly this?
That's a case called Parrott. So that is that's a 1913 case. So
yeah, but the employment was
so
1911.
The Act is 1911.
Yeah.
Sorry, you're making a mistake asking a lawyer to sort of start talking about... You're making a big mistake asking, if you want pithy answers, asking a lawyer to talk about a case. But it's a 1913 case in which the argument was, do you have to show to bring a prosecution that we're actually at war, that an enemy is defined by somebody we are actually at war with? And it might be thought, unsurprisingly, in 1913, on the eve of war, where the allegations included spying on the British fleet up on the Firth of Forth, that the courts concluded you didn't actually have to be technically at war to be an enemy, but you could be somebody whom potentially we were to go to war with. So that was the decision in 1913 in the case of Parrott. And then we don't really get any consideration of the meaning of enemy by our appeal courts, which set the law, until we get to Rousseff, which is the recent decision that I know you've been looking at carefully.
Lord Sebel, did you want to come back in?
Thank you, if I may. Two quick questions, Attorney. You keep using correctly the word enemy, that's the word in the legislation, but the appeal court, as Dame Emily pointed out, essentially redefined that to talk about a threat to national security. And had Mr. Collins been on the witness stand, he would have been able to demonstrate, as he has in his witness statement, that there are a whole raft of ways in which China is a threat, was and is a threat to national security. So although he would not have used the word enemy because it was not government policy, and that would never have been the case, as Lord Watts pointed out, he could have demonstrated China being a threat to national security, and therefore the jury could have reached a conclusion on whether that amounted to the enemy test as you set out. And that's what we're struggling with, which is why was that possibility not pursued to allow a jury to make that judgment? Can I just ask, and you may want to come back to that point again, but that's what I've been listening very carefully to. I just want to come back to this point, though, about the 3rd of September and thereafter that Lord Boateng was pursuing with you. You correctly said, constitutionally, you're only there to be informed. You obviously interrogated the decision in the way that you've set out, but it was a decision that had already been taken. However, we did hear evidence that, in effect, that wasn't a final decision, because there was then a period of reflection of 5 or 6 days, I think, in which where the DPP essentially allowed the possibility for government to consider whether there was more that could be provided, whether that might get across the threshold that government clearly thought they had passed. DPP had concluded they hadn't. And can you just explain to us what your role was during that period for reflection, and what you think should have happened during that period, or could have happened during that period, that might have brought us to a different conclusion?
Yes, of course. Can I deal with both of those points? And again, when
Please.
I come back to Rousseff and the 1911 Act, I'm giving it to you from my perspective, standing back, trying to understand not least what lessons here can be learnt. In terms of the actual decision-making that took place, you've got the evidence of the DPP and of Mr. Little. The Rousseff case didn't redefine the statutory test. So what Rousseff said is it's not just at war or about to go to war, as per Parrott. You can look at other factors, such as is it a threat to national security? Is the country concerned a threat to national security? But it's not suggesting you don't still have to satisfy the enemy test. What the Court of Appeal is saying is you can build your case on enemy, subject to fact and degree, on the basis that this country is a threat to national security. But the jury still have to be satisfied, and will be directed that they have to be satisfied that it is such a threat to national security that it amounts to an enemy. And the difficulty I anticipate, and the fault with the 1911 Act, is that, right? It requires you saying that. And the difficulty in prosecutions, and it would have been a difficulty here, is not simply where the government of the day is neutral on that issue, not a question of just leaving it for the jury unencumbered by the views of the government of the day on the question of enemy. The view of the government of the day is that China was not an enemy, and indeed, I've no doubt there would have been plenty of reference to where the government of the day was saying it's too simplistic to call China even a threat or an adversary.
But it did also say the term enemy should be approached in a common sense way.
Yes, but you, of course.
And the bastions of common sense are a jury. You would have looked at the overall evidence and decided whether or not that amounted to enemy, whatever the government.
Well, the point is it was not an exhaustive test.
It is not an exhaustive test, but and look, again, I want to stress, you've had the evidence of the actual decision-making in this case and the factors that were brought to bear by the director. But this committee will no doubt want to look at the Act and consider the difficulties that the Act generally gives, or gave, fortunately. It's no longer relevant. Enemy was still a test that the jury had to be satisfied was met beyond a reasonable doubt. And it is inevitable, I anticipate, that defence counsel would have been repeatedly making the point, not simply that the government of the day was neutral as to whether or not China was an enemy, but were saying that it was not an enemy. So that threshold, fact and degree, they would say was not met. And that is the type of problem that the Law Commission identified with the Act. And it's again why, to my mind, it was so imperative for Parliament to have acted sooner than it did to bring into effect the National Security Act, which would have obviated all these difficulties. We'd now be looking forward to that prosecution commencing.
Let's move us on. I'm interested.
Sorry, Mr. Chair.
Sorry, Lord Sedwell.
Oh, I'm so sorry. There's a second part of Lord Sedwell's question. So, when I'm informed, which is in the late morning of the 3rd of September, it's conveyed to me as a decision has been taken. I am told that the DPP would also inform the Cabinet Secretary that day. I'm asked to keep that information confidential. There's nothing unusual in that in terms of information that's provided to me by the DPP.
Understood.
And obviously I respected that. I'm told the next day that as a result of the conversation with the Cabinet Secretary, there's going to be a further discussion with the witness, Mr. Collins. I'm told, I think a few days after that, that that has taken place, but the decision remained. I did not consider it appropriate. I didn't think it constitutionally appropriate. I didn't think it permitted by my role as defined within the framework to be anything other than informed at that stage. But obviously, I was heartened to hear that there was a further attempt that was going to be taken, and disappointed again that it didn't lead to the prosecution continuing.
Okay, we might put some of those points also to CDL, because if it wasn't appropriate for you, that it was obviously within the Cabinet Office that further consideration was happening.
The evidence that the Deputy National Security Advisor gave on this question is what happened in effect, and I don't think there's anything further to add beyond the testimony he's already given.
Lord Tunnicliffe.
Could you just help me with the evidential test that the Crown Prosecution Service must take? I understand it's conditioned, but I've forgotten the condition. It might be a reasonable chance or something like that. So does that mean if there's only a 10% chance that it won't be taken forward, does it mean that a 50% chance may be taken forward? And is it just clear that a 70% chance that it definitely would be taken forward?
Shall I, for accuracy, just read you the relevant bit of the Code for Crown Prosecutors for the evidential test, which says this: it means that an objective, impartial and reasonable jury or bench of magistrates or judge hearing a case alone, properly directed and acting in accordance with the law, is more likely than not to convict the defendant of the charge alleged. This is a different test from the one that the criminal courts themselves must apply. A court may only convict if it is sure that the defendant is guilty. So in effect, the prosecutor has to kind of apply a kind of a balance of probabilities type assessment, whereas the jury has to apply beyond reasonable doubt assessment.
Okay, just want to move us on. Why is it, Lord Hermer, that when it comes to a case, in certain cases the Attorney General is consulted before a case is dropped, say, on public interest grounds, but when it comes to evidential reasons, is only informed? What's the difference?
So the consultation on public interest grounds only arises where the Attorney General has given consent previously. So it's not a general consultation on public interest grounds for all prosecutions. And one of the purposes, I anticipate, of Parliament giving to law officers the obligation to consent to certain types of prosecutions is that it's felt appropriate, not least that there's real consideration given by law officers to the public interest in that prosecution, because they fall often in the national security realm, in which broad considerations of public interest may be appropriate to take into account. And so I anticipate that the distinction that you see in the framework agreement between consultation, where a director is minded to drop a prosecution on public interest grounds, where that's consultation, the distinction between that and merely informing after the decision on evidential grounds is for that reason. And I think it would be particularly dangerous for politicians, whether law officers or otherwise, to be getting involved in evidential considerations. That really is something that needs to be left to independent prosecutors. So I hope that explains the division there.
Thank you. Sir Gavin Williams.
Thank you, Mr. Chair. So, as Attorney General, you do have a statutory duty to superintend the Director of Public Prosecutions, and it was quite interesting to listen to Mr. Parkinson and Mr. Little the other day, because it was quite clear from the evidence that they gave that they were highly concerned about the evidence and the evidence that had been provided. And they were quite clear that they were explicit, or as clear as they could be, to others about the need for the evidence. Your letter states that the CPS could seek assistance from the Attorney General in, to quote, securing evidence or disclosure from other government departments. Can you just set out to the committee what actions you took in order to ensure that the evidence that was required was provided to the CPS.
Yes, of course, Gavin. So you would have seen from the passage in the framework agreement that it provides a means for the Director of Public Prosecutions to approach me if it is felt that I could be of assistance in unblocking any evidential inquiries, and no such approach was made to me. As I understand it, ultimately, and you've had the evidence, they received the evidence from the Cabinet Office. It wasn't a question of not receiving the evidence that led to this prosecution not proceeding. It was the contents of those witness statements that led the CPS to reach the views that they led. And obviously, even if I had been contacted by the Director to try and unblock any difficulties in obtaining evidence, I couldn't possibly have intervened to have any influence over the content of any witness statements. But in any event, I received no request.
Okay, but did you ever check with them as to whether they needed any help? Did you proactively?
No.
No,
and it would be, I would imagine, anticipated. I beg your pardon, unprecedented for a law officer superintending the CPS to anticipate problems in any given case and say, what can I do? I know that the CPS and the Director will know that I'm always available to assist where appropriate.
Yeah. No, that's very good. You spoke very warmly of Mr. Collins earlier, and I think we'd all share your view on him about being a very committed civil servant. And I think you'd probably agree with me, he's very much an expert in his field, isn't he?
Yes.
Very knowledgeable about what he does and the field that he's worked in for a long time. Would you describe him as an expert witness?
Is Matt Collins a...
Well, yes or no? I mean, is he an expert? Is he an expert witness?
It depends.
Well, I mean,
no.
I think...
Is Matt Collins...
Can we just sort of get to a yes or no?
Forgive me, right? Well, forgive me, because an expert...
Do you want to give
there's
three
a difference
answers?
There's a difference between an expert and an expert witness. Yeah. Is Matt Collins an expert on the issues, as we would all understand it in the everyday meaning? Is Matt Collins an expert in the national security threats that we face in this country? Absolutely is, and we are lucky to have him. Is he, for the purposes of a criminal trial, and here's a term of art, an expert witness? In this case, he wasn't an expert witness. He was what I think most accurately could be called a corporate witness, giving evidence of the government's position at the time. I'm sorry to be pedantic, but it is quite important from a legal perspective.
Anything less. But we've established he's definitely an expert.
Yes.
Oh, absolutely. So I'm afraid to say, unlike Lord Boateng, I'm not a lawyer. So can I ask you a bit of legal advice? As a lawyer.
Well,
I proceed to ask.
I think I'm here as Attorney General to answer evidence that is...
Don't worry, sorry, it's not on my home conveyancing or anything else like that.
I think you'd be in trouble if you were relying on me for that. But let me just be clear, if I may, Sir Gavin. I mean, I am here to assist the committee in giving the evidence that I'm able to give as to what I could see from my superintendent's position.
We've got quite limited time, so if you wouldn't mind just sort of pausing for a moment.
Yeah, of course.
So all the way through the evidence that Mr. Collins was giving, he kept falling back on the simple line that the government's policy position, repeatedly again and again, this was the government's policy. And we asked him, and he has been asked numerous times, as to what his judgment is. What is his assessment as an expert? Not what government policy is, but what is his assessment as an individual, as an expert in terms of what we're facing. But he continuously refused to do that. And with your great legal mind, under Criminal Procedure Rule 35.3, experts' overriding duty to the court is to, one, it is the duty of experts to help the court on matters within their expertise. And secondly, this duty overrides any obligation to the person from whom experts have received instructions or by whom they're being paid. Now, I'm not a lawyer, but looking at that, to me, that says that he should have been willing to give his judgment of his assessment, not purely what government policy is. Is that correct?
No, I think, and I'm sure I'll be corrected if I'm wrong, I think what you're quoting from is not the criminal, I don't know how you described it, I think what you're quoting from is the civil procedure rules. And Part 35 governs the conduct of experts instructed by one party or another in a civil case, not in a criminal case. I'll be corrected if I'm wrong, but if I can give you the answer to the question that you asked. So I think you're quoting, with respect, rules that are inapplicable to criminal proceedings. They govern civil proceedings with very different considerations about experts who are instructed by one party. Here, Mr. Collins is asked, he's contacted and his evidence is obtained by the counter-terrorism police, and he's asked to give the evidence that he gave. I don't think we can criticise Mr. Collins for that. I don't think we can criticise the counter-terrorism police for doing that. It wouldn't have prevented, of course, the defence cross-examining him more widely, but there was nothing, I think, inappropriate or improper in asking Mr. Collins to give the evidence that he did. And I really don't think you get much help from the provisions that you just quoted at me.
Is it usual, Lord Hermer, for there to be very senior meetings to be held between charge and trial on cases within Number 10? Is that something that you would usually see happen? I mean, how many instances are you aware of, other than this one on the 1st of September? How many times have you heard this happening in relation to other prosecutions? 10 times, 20 times, 30 times, or just one time?
Let's be really clear, Sir Gavin.
Just do a number. You don't have to do lots of words, just a number.
I am unaware.
How many times, Lord Hermer? How many times? Go on, how many times? Just out of curiosity. Once, twice, three?
Sir Gavin, we're discussing grave matters of national security.
Yes, and how many times do you have a meeting of senior civil servants between trial and prosecution, between charge and trial, discussing that case? How many times? You've been Attorney General for over a year. How many times has that happened while you've been Attorney General?
Yeah, please try and keep your tone. Degree of respect.
Is it once, twice, three times?
Well, it's very hard to get an answer in, if I may say so, when I'm given no
just
opportunity to reply. So I have never been, and I suspect I will never be, in a meeting at Downing Street to discuss details of the evidence of a case that is about to proceed
Your
at
Permanent
trial.
Secretary was there. How many times has such a meeting happened?
No.
Has it happened before? Are you aware of any? You've been Attorney General for over a year. Has it happened on any trial, on any cases between charge and trial in your time as Attorney General?
So, Gavin, this committee is rightly concerned
We're just interested
about
in
this
the answer,
prosecution of
Lord
national
Hermer.
security. Now, we can either treat this...
just answer the question.
No, I'm going to answer...
I asked how many times there's been a meeting to discuss a prosecution that has taken place between charge and trial that he is aware of with...
I anticipate that, and I would certainly hope...
Zero.
There has never been a meeting... There's never been a meeting to discuss the evidence in a forthcoming trial. And that certainly that certainly did not take place here. What happened on the 1st of September is that there was a meeting that, amongst other things, considered the handling of a trial that everybody at that meeting proceeded on the basis was going to commence in November. That is what you would expect a responsible system to anticipate in a case such as this, the handling questions. There is nothing improper, and if I may say so, trying to insinuate bad faith into our national security making decisions does nothing to increase public confidence in it. It simply seeks to undermine, and that is very dangerous, whereas here it is baseless. and it simultaneously undermines confidence and trust in our criminal justice system. And
usual?
all politicians, not least privy councillors, should be mindful of that, I would respectfully say.
Move us on because we're going to run out of time and there's a lot of ground to cover. So, Baroness Tyler, you wanted to come in on the same point.
Yes, Attorney General, this is one very specific point about the involvement of your office in this case. I'm sure you'll remember that yesterday you answered questions to a repeat question in the House of Lords, and Lord Keane asked you a number of questions, and he ended up by saying, can the Attorney General confirm that his office reviewed the witness statement submitted on behalf of the government? You gave a comprehensive answer to that because he'd asked a range of questions, but I didn't see the specific answer to whether or not your office had actually reviewed the witness statement submitted. I just wondered if you could help on that point.
Other than the Solicitor General, at the time the consent was granted, there would have been no reviews of the witness statements themselves. I wouldn't have expected that to have taken place.
Thank you.
Baroness Fall.
Thank you very much, Chair. I want to turn to you, Mr. Jones. You entered Downing Street literally in the middle of the fray, as it were. I think you started in your role at number 10 on the 1st of September, if I'm correct, and then you became CDL on the 5th of September. Were you aware of the Cabinet Officer ministers being briefed on the case as it progressed? Either, I mean, it would have been before your time.
So no, I wasn't.
Not aware. And when were you yourself briefed on the case?
On the 15th of September, when the CPS confirmed publicly its decision not to proceed with the case, and I was read in on the detailed briefing that the Prime Minister received on the same day.
So in your time at number 10 and then at your time in the Cabinet Office, you weren't briefed on it until then?
No.
Not at all. So you didn't attend this meeting that we've just been talking about on the 1st of September?
No.
Did any of your special advisors or officials?
No.
So you had no report of that meeting whatsoever?
No.
Did your predecessor?
I don't think so.
You'd know that, though, wouldn't you?
Well, I don't know the diary of my predecessor with respect, Chair. I mean, you might be able to ask him that question, but my understanding is there were no politicians in that meeting on the 1st of September. I think it was just officials.
And no special advisors?
I don't think so, no.
Of your predecessor?
I don't know about my predecessor, but my understanding is there were no politicians or special advisors in that meeting. It was officials.
Okay. And you were told when the case dropped?
Sorry, I've just been informed, Baroness Ford, that Jonathan Powell, as the National Security Advisor, who of course is a special advisor, was in that meeting, but my predecessor special advisors as CDL were.
Thank you. And yes, we were aware of that. Thank you very much for that. You just said, so the case, you were aware that the case dropped on the 15th of September, you just said.
Yeah.
And at that time, did you discuss pursuing any alternative options?
No, because it was too late. The decision had been taken and had been announced.
So you didn't pursue the idea of having some sort of confidential closed statement?
I didn't, no.
And the same question to you, Lord Hermer. Did you ever discuss the possibility of a confidential closed statement to support the case?
No.
Okay.
I really don't think it would have been appropriate for me to be diving in and directing this prosecution.
Thank you, Chair.
Lord Robertson, did you want to come in, or can I move on?
Come in on a wider issue, which is we were told that on 10th of July the Cabinet Office was told by email that the wording, I quote, active espionage threat, unquote, does not go far enough to meet the prosecution's needs. Now, I can't find exactly who sent it. Perhaps you might know who sent this email. But were you aware of this issue as early as the 10th of July? Do you know who sent the email?
I'm afraid I don't know who sent the email. I was aware the case was proceeding. I receive a list of the most serious cases from the CPS on a monthly basis for information. That's normally just a few lines about each of the top cases. So I knew about this case proceeding. It had been brought to my attention that there had been some historical difficulties in getting timely witness evidence, but at the time of each of those reviews, steps were underway, either with assurances it was about to come or that it had been received.
I'm sorry, can I clarify?
Of course.
Darren Jones wasn't, of course, there, but the Cabinet Office were told by email, so I don't know if you know anything about that, but did you know Attorney General on the 10th of July or not?
No.
Okay.
Mike Martin.
Thank you, Chair. And just briefly, if I could just pick up some of these threads as well about who knew what when to Mr. Jones, please. So, well, as this case progressed, to the best of your knowledge, Mr. Jones, were any other government ministers informed of its progress or lack of progress as it progressed?
No, I don't think so.
So, and I obviously I understand that it's difficult for you to know exactly what your predecessor knew, but hopefully you did a sort of a handover takeover on the 1st of September. But were you aware before you came into post that they were meeting on the 1st of September to discuss the case? Did you hear anything about it at that point in time?
No.
Okay. And did you know, when did you hear that the government's evidence was insufficient to put the case to trial?
On the 15th of September, when the CPS confirmed that they weren't proceeding with the trial.
Okay, so right at the end of the process. Okay, and then who informed the Prime Minister? When was he informed? And was there any further action taken by the government after that point?
I think you will have had evidence from Matt Collins and the Cabinet Secretary yesterday on that point. My understanding from their answers was that Matt Collins had informed the Prime Minister verbally a number of days before it was made public on the 15th. The Prime Minister received some further information, but at a lower level of classification when he was at Chequers on the preceding Friday. He was then fully read in on the detail on the same day that I was on Monday the 15th of September.
Thank you very much, Chair.
Edward Morello.
Thank you, Chair. Going back to the earlier point of lessons learned and thinking about the future, you mentioned already that the current National Security Advisor is a political appointee, which creates a number of issues, not least of which we've had trying to get him to appear in front of this committee. But I'm just wondering whether or not the fact that he is a political appointee creates any difficulties in oversight. We had the Cabinet Secretary note himself in his evidence that he doesn't have a deep background in security matters. So are there any issues around going forward in cases such as these and oversight with having a political appointee in this role?
I don't think so. I mean, I think if you think about Jonathan Powell, I think everybody would say he's one of the best people we have in our country to perform this role, and so the Prime Minister wanted to appoint him to do it. We're very grateful to have Jonathan's expertise and skills available to us as a government, and he's added enormous value to our work. As an appointment of the Prime Minister, he was not a civil servant. Previously, he's been appointed as a special advisor. But you'll have seen in the Deputy National Security Advisor, who is the civil service head of the National Security Secretariat, that we have an equally experienced civil servant with a whole team of people who perform their roles very well indeed. Cabinet secretaries, of course, may come from different backgrounds all of the time, but that's why the National Security Secretariat is housed with that expertise in the Cabinet Office. So I don't think there's any suggestion here that Jonathan Powell's appointment as the National Security Advisor or the Cabinet Secretary not coming from the national security background is an inherent problem in this case, and that therefore should be considered differently in the future.
I don't think there's any suggestion of any issue with the credentials of the NSA, but we do have now a situation in which it's very difficult for this committee to give scrutiny to a SPAD. You can't have the NSA reporting into a SPAD, so you've got them reporting into a Cabinet Secretary, again, who's, by his own admissions, background is not necessarily around national security. So we are creating, I guess what we're trying to talk about here, if we are being positive lessons from this, is have you, as a result of this, created a reporting line that will create problems down the line?
I don't think so. My understanding is that Jonathan Powell is coming to give evidence, I think, to Parliament. I think he's appearing before the Intelligence and Security Committee, and of course he has co-signed written evidence to the committee as part of your question.
Also, I'd like to go back to the evidence provided by the DNSA for this this case, in which, you know, use of the word enemy aside, he does outline that China is a threat to national security, that it is an advanced, persistent threat, that it is continuous. Lord Hermer, you've been very clear that the Official Secrets Act was rightly superseded by the National Security Act because it was redundant. But if we are facing a threat to our national security, one that is continuous, that is greater than just this case alone, is it not right that China should be on the enhanced tier of FIRS?
Well, I think there are two questions there, one of policy and one on the FIRS question. On policy, I think it's plain for everybody to see from the evidence that it can be true that China poses a series of threats to the country, but also a series of opportunities. Both of those things are true. That's why our previous Foreign Secretary, why this government's made it clear that on issues where we seek to collaborate, whether on climate change or through international fora, we will do so. Where we can improve trade whilst being mindful of national security threats, we will do so as well. China is the second largest economy in the world and our third largest export partner. But it's also then true that we need to have the appropriate toolkits in place to manage those national security threats. Now, the National Security and Investment Act, which the previous government legislated for, which I'm now the quasi-judicial decision maker for, works, in my view, very well on questions of economic issues, buying companies or assets, different changes in financial structure, shareholdings, equity, and those types of issues. That works well. It's good that that legislation is on the books. But as the Attorney General's made clear, the problem really at the base of all of these questions is that the National Security Act 2023 came a bit late in the day, and as we'd heard from Lord Sedwell, if the previous Conservative government had granted time for the last government to bring that legislation forward, that would have made life much easier.
If we accept the evidence that has been submitted by the DNSA that there is a continuous spying threat from China, do we not owe it to protect ourselves for the future cases that are undoubtedly going to arise from a persistent, continuous threat, to have China on the enhanced tier of FIRS, which means that any future case is guaranteed and we don't have this issue of enemy?
Sure. So I think the legislation we now have on the books is sufficient, whether it's the National Security Act or the National Security and Investment Act. We have the provisions in place now to be able to deal with these issues where we hadn't done in the past in relation to this particular case. Your question on FIRS is something that the government obviously considers in the proper way. It's a new framework that's been introduced. It's only come into effect at the start of July this year, and government will need to come to Parliament with any consideration on that. We'll therefore do that process in the proper way. But I don't think, as the Attorney said earlier, whether China is on the FIRS list or not, that would have undermined a successful case being brought forward under the new National Security Act, which our view is that would have been okay.
Thank you. Emily Thornbury. Dame Emily.
Just on lessons learned. So I suppose one of the few positives, and there aren't many, to come out of the collapse of this case is that it highlights and it begins to inform the public that the world's second biggest economy, from whom we get all our stuff, or most of it, also poses a considerable security threat to our country as well. And do you agree that there should be more public discussion about this and more understanding by the public of this?
Look, I think this case has made this a public conversation. We've been very clear as a government about our assessment of those threats and also the opportunities. Other officials in government, for example, head of MI5 is as well, with his annual speech, for example. I think the thing, if I think about my constituents and the public, what would they want to be reassured of? They want to be reassured that we have the powers and the tools in place to deal with and manage those risks, to robustly make the case when our Foreign Secretary or the Prime Minister is meeting with their counterparts in China, but also to have a grown-up relationship with China on issues where we do need to collaborate on the world, like, say, for example, on climate change and other issues. And my point is that now with the National Security Act and the National Security and Investment Act, plus the additional work that's being done through the Defending Democracy Task Force, working in partnership with Parliament to ensure not just that members of the Houses here in Parliament but mayors and councillors and other politicians across the country are given the support and the advice to be able to spot and deal with potential attempts of phishing or cyber espionage or people trying to bring influence over their decision making, that we are doing everything we can in a robust way to manage and deal with those risks, whilst also having a grown-up relationship with an important country in the world.
I think, sorry.
I really time for time.
Do you mind if I just ask one more, please? Just because I just wanted to ask this because it's something that my committee has been kind of quite focused on. I hear what you're saying, but do you not also think, in those circumstances, that it would not be to the good of this country to publish the China audit and the strategy attached to that audit so that we have a proper structural understanding of what the threat is to China? I hear what you say about filtering it through to councillors, but why can we not be trusted with a document that is properly studied and considered the positives and the negatives when it comes to our relationship with China?
Sure. The National Security Strategy is a document, is a public document that explains the government's assessment and position on those questions. The China audit itself obviously had a level of information and collaboration that was at different levels of classification, so you wouldn't naturally publish it in a document for the whole world to see because you'll be going into more secret information. So the National Security Strategy does do that, but I think it would be improper for us to suggest that we should publish information at higher levels of classification into the public domain.
Andy Slaughter, very briefly.
Do you, in the light of the importance and the rarity of this case, do you think there should be any further legal or administrative review, either about the decisions that were made? Because clearly we've heard strong evidence on both sides as to was there evidence to proceed in the case, and if that was in doubt, should that evidence have been tested in court, and should more evidence have been sought if the DNSA's evidence was not sufficient? So there's that whole package, if you like. There's also the issue of what the misunderstanding, the fact that the DNSA clearly thought he had done enough, and the DPP thought they hadn't, but that they communicated that he hadn't, and yet those messages were never linked up, and that seems to be quite serious failing. So the potential of that happening again means we really have to get this right and find out what went wrong, from a legal point of view, but also from an administrative one.
Look, I think any good government wants to learn lessons from episodes, whether happy ones or unhappy ones. I'm going to look forward to consideration of the conclusions that this committee reaches. I know the ISC is also looking at the matter. Obviously, I'm going to keep thinking, as I do across a range of issues, about how we can do things better. I think that's our obligation in government to be doing that, and I don't think this case is any different.
If I may, Chair, I'd just add from an administration perspective as opposed to a legal perspective, the accusations that have been made of the government, predominantly from the Conservatives but also from others, was that there was political interference in a criminal process, which is a grave accusation. That's been proven to not be the case. That means the process has worked in the way it should work. It's a bit odd, if I might say, that the Conservatives have then said, well, why did you not politically interfere in the case? Well, that's because that's not how we do things in this country. So I think at the administrative level, the independence of the CPS, the role of ministers, the role of the attorney, that has all worked as it should do. And really the questions, I think, are of law, which has largely been dealt with by the introduction of the new Act.
Baroness Tyler.
Thank you. This is for the Chancellor of the Duchy. Could just go back to the point about how the government is sort of reconciling its ambitions to pursue economic opportunities and at the same time not compromising national security. I just wondered what lessons you have learned, or how have you looked at how other countries approach it. I mean, I understand that Australia, as commentators have suggested, are quite ahead of the curve in terms of what they do both to pursue, I think China is their largest trading partner, but having taken sort of robust steps to try to tackle any Chinese covert influence at home. And I know Chatham House also recently suggested that there was more the government should be doing to boost resilience against espionage threats. And did you agree with that sort of line of argumentation?
Well, evidently there's more that needed to be done through the Defending Democracy Task Force, because a lot of these attempts can be quite subtle, and I think lots of people have been subject to, I think they're called phishing exercises and all these types of things. That's why the work here in Parliament has been really important. There's now enhanced security provision for members of both houses, enhanced advice, enhanced cyber advice services that have been made available to us. And as I said to Dame Emily, the recent decision to extend that beyond Parliament, other political decision makers across the country, I think is the right one.
Could I just pursue again? Have you looked at how other countries have handled this issue and seen if there's any lessons that can be drawn?
So the Defending Democracy Task Force will have done, yes, and more related to my work in respect of the National Security and Investment Act, there's definitely comparisons to how different countries around the world work, including with Five Eyes partners and others. Our regime, I think, is seen as being internationally robust and good, and it also makes it very clear on the face of the bill to China or any other country or any other investor which sectors we consider to be critically important to our national infrastructure and our resilience, and which transactions, therefore, we reserve the right to look at in detail and stop if we need to do so.
Thank you.
Lord Hutton, did you want to come in?
Well, just very briefly, thank you, Chair. I mean, just to go back to what you said a second ago, Mr. Jones, I think I heard you right in saying that you think the system had worked well in this case. I don't think that's probably how many members of the public view this. I mean, it looks like a car crash, doesn't it? You know, we've got espionage activity that goes unpunished. We've got certainly a loss of public confidence in the criminal justice system because wrongdoing has escaped, as it were, any kind of accountability. And yet I don't really hear either of you saying that you think there's nothing further that we should perhaps be thinking of doing to prevent this kind of thing happening again, because I'm not entirely sure the government is going to not find itself in a similar situation, even under the national security legislation that was passed a couple of years ago, if it cannot identify and commit to saying that China poses a threat to our national security.
And perhaps not just a loss of public confidence, but a confidence amongst the CTP, amongst all those investigators, and maybe amongst our security services as well.
My point, Lord Hutton, is that the root cause of the problem here is that the case in question was charged under very old legislation, which the attorneys already talked about in detail. Had the new National Security Act been implemented sooner, following advice from the Law Commission, we would not be here having this conversation today. The point I made in response to questions from colleagues was, had the process of the constitutional separation of politicians and the government from the independent decisions of the CPS and the role of the attorney worked well? The answer is yes, because everything was done properly, which was very different to the allegations that were being made by political parties.
No, I absolutely understand that point, and we've not heard any evidence that implied there was any political interference in this process, and that's been very welcome to receive. But I still get the sense, I'm just concerned about maybe some inherent complacency here, that the lessons somehow were learned before this case came to trial, or failed to come to trial, because the legislation was changed in 2023. I'm just not as confident, perhaps as either of you are, that we might not find ourselves in the same position again in the future if this inherent reticence on the part of government to really call out the dangerous nature of Chinese espionage activity is not going to be done.
Let me try and dispel any notion of complacency. So as you know, the first duty of this government, as in any government, is to protect the national security of this country. And every arm of the state, counter-terrorism police, politicians, the independent Crown Prosecution Service, will work night and day to ensure that those people who harmed the national security of this country are held to account. Now, we were hamstrung in this case by an outdated bit of legislation. We now have legislation that is fit for purpose, and we will use that legislation whenever there is credible evidence that people are seeking to damage the national interest of this country. There is not a jot of complacency, there is only determination.
Lord Hermer, perhaps we could write to you just about how things could have worked better, because I think there is clearly frustration in this short session that we've had, that things haven't worked well. In fact, someone used the term car crash. And I think that's the wider public perception. But can I just come back to one point, which I think you said on a couple of occasions, that you haven't reviewed the full set of papers that were left by the previous AG. Given the seriousness of this, the real seriousness of this espionage case, they don't come along like London buses, why is it you've not?
Well, because the question has got to be, for what purpose? So if the purpose is, the only purpose of reviewing absolutely every last scrap of paper would be effectively to second guess a decision whether or not to prosecute. If the question is, am I ensuring that I am seeing everything that I need to see so that I, as superintendent, can be reassured that all lessons have been learned, then the answer is I have seen, and insofar as there is further material for me to see, not least the conclusions of this committee, that will help me in that task, then of course I will consider it very carefully.
I just want to finally return to the point about confidence and about what this says about us. And I think Baroness Tyler was right when she was asking about how other countries may do this. She cited quite rightly about Australia and some of the challenges that they faced in recent years, which you may be familiar with. Something like 32% of their exports go to China. So they are very dependent on China in their economic relationship. But they've demonstrated a much more muscular approach in their relationship with China, yet we appear, and this is the public perception, that we are kowtowing to China in our approach. What would you say to that, Lord Hermer?
I can absolutely reassure this committee, and through this committee the public, that this prosecution failed not because anybody in government kowtows to any foreign power. It fell down for the reasons given about a conclusion reached by the independent Crown Prosecution Service that the evidential test was not met. And what is more, this process has exposed the both baseless and dangerous allegations that somehow politicians intervened in a prosecution to stop it because of fears about a foreign power. Those are baseless, and it is those allegations that I suggest are the ones that cause the most long-lasting damage to both our national security reputation and our criminal justice reputation.
Chancellor, what's your view?
I wouldn't agree with the sentiment in the question. I would contrast it maybe to recent foreign policy. Under the last government, the position was not to talk to China at all. I'm not sure that's very muscular either. It's right that we have a working relationship with the Chinese government and their officials, and it's right that we are robust in dealing with these issues and being very clear about that. We do that now because we are having conversations with counterparts in China. I think if you were in a world where you continued with the policy of the previous government, where you just don't interact at all, that's not going to stop anything from happening. And so actually, as the attorney said, we are robust where we need to be. We're very clear about that. The powers that we have now are sufficient, and they're on the face of public legislation for everyone to see. We exercise those powers routinely in respect of, for example, the National Security and Investment Act now. And that is a much better way to conduct business than has been done in the past.
But you'd accept that the China audit, for whatever reason, this committee has not been able to have access to that entire document. So there's a real sense of opacity at the heart of this government that they don't want us to know, they don't want the public to know, and therefore there is a perception of concern about how the government is operating in its relationship to China.
I'm sorry that the committee feels that way. That's certainly not the case. I think we've been very clear, whether you look at the witness statements here that would be made in open court on behalf of the government had the case proceeded, or the evidence that we or our civil service counterparts have given to Parliament this week, that we don't shy away from the series of threats that China poses to the UK, either in public or in conversation with our Chinese counterparts.
Right. Well, look, I think we are there, more or less. Can I thank our witnesses, Lord Hermer, CDL, for your time today. We may have further questions. We may come back to you in writing. We may indeed may ask you back for another session. But for today, that concludes our session. Thank you all.